Hi everyone and welcome to our next video. In this video, we're going to be talking about an example of logical reasoning and trying to figure out what kind of reasoning we're using at the end of it. Okay, so let's jump into it. If you were with us for class, you'll already know what kind of reasoning this was, but it's still a good way to get some practice with it and get some ideas and be able to review what we did in class, right? So let's check it out. So this example is going to be based on Law and Order, courtroom justice, right? Courtroom sketches, one of my favorite pieces of art, a beautiful and historic art practice I hope survives forever. Now, the prosecutor in a criminal case is presenting to the jury the following evidence against the accused. Number one, the accused has no alibi. Number two, they failed a lie detector test. Number three, eyewitness testimony has identified them as the culprit. And now they need you to decide if you were on this jury, would you declaim this person to be guilty without a doubt? Why or why not? So think about this. Maybe take some time to think about this. Pause the video for a minute or two and consider: would you claim this person is definitely guilty or not? All right. Hopefully you paused the video and thought about it for some time till you had a conclusion. Hopefully you have some good explanations. Let's see if I can skewer some of those. I'm going to take the role of the defense. So my job is to show not that the client is guilty or innocent, right? But that this evidence is not enough for them to be guilty. So let's break it down. Here's the three pieces of evidence we have. How could someone be innocent and have all this evidence appear? Or another way of thinking about it, right? Why is this evidence not enough for guilt to be the certain conclusion? Because the prosecutor would like you to believe that, right? And in the courtroom, they might say it. Only a guilty person could have all of this evidence stacked against them, but that's not true. So let's break it down. Does having no alibi mean you're guilty? For people who aren't aware, an alibi is a statement or some facts you provide, right, that make it impossible for you to have been at the scene of the crime. For example, I was in another country when the crime was committed, or I was on security camera footage at the time the crime was committed, right? Those are examples of alibis. I couldn't have been present at the scene of the crime at the time the crime was committed, so I couldn't have done it, right? Okay, so that's definitely a way to prove innocence, but does not having one mean you're guilty? No, right? Maybe you were home alone enjoying a nice bubble bath. Nobody was there when you were taking your bubble bath, right? Doesn't mean you weren't taking it. You have no one to prove that you were home alone during this time, but you could have been, right? So this is not the absence of proof of innocence does not mean guilt, okay? Does not equal proof of guilt. Very, very important thing for people to understand, okay? Not being able to prove you're innocent is not the same thing as being guilty, okay? That's not the same thing. Okay, so what about this one? Failing a lie detector test. Unreliable, right? Lie detector tests are not necessarily going to work. Lie detector tests have room for error. In fact, in many states, lie detector tests are not admissible in a courtroom because they're so unreliable. Lie detector tests are valuable not because of their ability to sort truth from lies, but instead as psychological value, as a way to press someone into confessing. The value of like saying this scientifically proves you're lying. They're like, okay, I admit I was lying. I'll tell you the truth, it works. It doesn't necessarily work as a way to sort truth from lies, but it works as a way to pressure people on the lies that they already suspect that person is telling, right? So it's unreliable. An innocent person could be seen as lying. They could still trigger the response, right? Now, why? Well, lie detectors don't immediately tell lie from truth. They tell stress and other physiological responses. And some people are going to be stressed when asked, did you murder somebody, right? Or repeatedly pressed about lying. So they might just have that response, and there's plenty of other ways that response could occur. Maybe they didn't properly read it, right? What about this one? Eyewitness testimony. How could an eyewitness saying you did it not be evidence of guilt? Well, the witness could be lying, right? Maybe they were the killer and they're lying about it, or they could be mistaken, right? Memories are not perfect. People can very easily be misled. There's been scientific studies where they showed people pictures of Bugs Bunny at Disneyland, asked them, do you remember when this happened? They go, oh yeah, and they tell a story about seeing a commercial for it or being at Disneyland when it happened and meeting Bugs Bunny. Never happened. Bugs Bunny's never been at Disneyland, but they believed it did when provided the evidence, right? In the same way, police often are very careful not to lead a witness into trying to fill in the memory in their gaps, but just asking them exactly what they remembered. Because if you go, are you sure they weren't wearing a hoodie? The person might now spontaneously remember that they're wearing a hoodie, even if they weren't. They might go, maybe that, yeah, they were wearing a hoodie. You're right. Because people are just trying to be helpful naturally. And in doing so, they can edit the memories. Every time you remember something, that memory is being edited, right? Very weird, but true. Memories are not constant and fixed in your brain. So eyewitness testimony is actually notoriously unreliable. It's not very good. But lots of eyewitnesses is what is the key, right? It's unlikely that everybody misremembers the event in the exact same way. Okay? So each of these three pieces of evidence has the chance that you could be innocent, right? You could be innocent without an alibi for sure. You could be innocent by even when you fail a lie detector test, not a guarantee, but you could be. And then an eyewitness could be lying or they could be mistaken. But if I have all three of these pieces of evidence, all three of them, is it likely that you're guilty? Probably, right? You're probably guilty. I could say, okay, I'm pretty sure you're guilty. All three pieces of evidence, it's unlikely that all three of these things was stacked against you, right? That seems unlikely. But could I say you're guilty without a doubt? That's the question. That's actually the ultimate question. That's the very question that our system of courtroom justice is founded upon. Let's explain that, right? Because notice, luckily in a courtroom, we don't have the jury decide if someone's guilty without a doubt. We have them decide on a different standard. We have them decide on the standard of guilty beyond a reasonable doubt. So what does that mean? Why do we do guilty beyond a reasonable doubt, right? Well, the idea is exactly what we're talking about. There's always a chance you could be innocent, right? You could have all the evidence in the world, not just those three things, but your fingerprints are on the murder weapon and your boot prints are in the mud outside and 50 people saw you do it and there's security camera footage of you doing it. And you could say, well, someone else was wearing those boots. Those were not my fingerprints. They were lifted from the glass I was drinking from and planted on the knife. All 50 people were hired by someone and they hacked into the security camera and edited the footage to include me. Is it possible you're telling the truth? Yes. That could have happened, right? Very well, there could be a giant conspiracy and hacking institution devoted to framing you for a murder or whatever. But is it likely? No, right? At a certain point, there's so much evidence towards your guilt, we would assume you guilty beyond a reasonable doubt. Everyone gets the reasonable doubt, right? We always go, is it possible you could be innocent despite the evidence I'm seeing? Yes. But at a certain point, that yes becomes a no, right? Is it possible? Yes, but, right? It's still possible, but it's so unlikely that we just assume you're guilty, right? What's that threshold of likeliness? If there's a 1% chance a person's guilty, sorry, if there's a 1% chance a person's innocent, do you feel comfortable saying they're guilty? What about a 5% chance of innocence? That would mean that 1 out of 20 people would be going to jail wrongly, right? Innocent people, 1 out of 20 people in jail would be innocent. Is that a standard you feel comfortable with? That's the question, right? And that's exactly what the founding fathers worried about, which is why there's other parts that contribute to this, okay? The courtroom system that we make has a not guilty verdict. We don't say people are innocent. We say people are not guilty, right? Why is that? Because in a courtroom, we're not proving innocence. We're proving guilt, right? Or convincing people of guilt, even. When we're presenting all this evidence, we're building up statistically more and more likely chance of being guilty. But if not enough evidence is presented or that evidence isn't good enough, maybe like the three pieces of evidence we had earlier for some people, that doesn't mean you're innocent. It just means I can't prove you're guilty. You still could have been guilty, but we just don't have the evidence to show me, right? That's why we presume not guilty. But in America, we have a presumption of innocence. So even if we can't prove you're guilty, right, we assume you're innocent. When you walk into that courtroom, we treat you as an innocent person with all the rights and respect that an innocent person deserves. And until we prove your guilt beyond a reasonable doubt, you are treated as innocent. Which means if we can't prove it, if the evidence isn't good enough, you get treated as an innocent person and you are free to go, right? This is important. The founding fathers very specifically put this in our laws and constitution because they thought, like we did earlier, that it was more important, right, for innocent people not to go to jail than for guilty people to walk free. When having to choose between these two outcomes, they decided, you know what? I will accept the chance that a guilty person can go free because I want less likelihood of innocent people going to jail. It's still possible, mind you. Innocent people have gone to jail, and 20 years later, DNA evidence exonerated them of their crimes, but it's just less likely. If we had a flipped system where people were presumed guilty when walking into court and we had to prove their innocence, it would be the other way around. More innocent people would be going to jail, but less guilty people would be going free. Is that a system you would prefer? That's a good question to ask, right? Okay, so putting this all together, we have a system that assumes innocence until proven guilty. And we don't really conclude definitively without a doubt that you're guilty. We just say it's likely that you're guilty. Judging by all of this stuff, do we have an inductive or deductive reasoning based system? The prosecution wants you to think it's deductive, right? They want you to conclude with certainty based on these facts that the client, the defendant, must be guilty. But is it? It's inductive. Our justice system is based on inductive reasoning. Think about it. We do not guarantee the conclusion. We only predict the likelihood. Remember what we wrote, right, in our last video and in our notes in class, that inductive reasoning is about likelihood and predictions and guarantees. It's about making conjectures, educated guesses based on observations, which are the evidence presented in the courtroom, right? We presume innocence if unable to prove guilt because we are only predicting the likelihood of guilt. There's always a chance our prediction is wrong, right? We cannot know for sure if people are guilty or not. And there you have it. Inductive reasoning is what we use in a courtroom. So if you ever need a good example of how inductive reasoning and probability works, consider the courtroom. And in fact, in science, when you talk about the null hypothesis in the future, and in statistics classes as well, when you talk about hypothesis testing, remember the courtroom example and you'll do a good job with it. Okay, I will see you in the next video where we go over another example of reasoning and see is it inductive or deductive. Until then.